for joining us today for our first ever real estate investor legal live stream. Today, I am with Florida attorney Al Nicoletti. Al's practice primarily focuses on probate matters. He is also very active in the real estate investor community. He even hosts his own podcast called The Al Nicoletti Show, in which he interviews investors and other real estate professionals. I am Sean St. Clair. I am the co-managing partner of the law firm of Fowler St. Clair, which has offices in Arizona and Georgia. I am also the founder of Real Estate Investor Legal, which allows real estate investors to connect and collaborate with attorneys nationwide. My mission is to have attorneys from all 50 states join our Real Estate Investor Legal Facebook group. So if you know of any attorney who has experience working with real estate investors, please invite them to join the group. I do have to provide a disclaimer for our show today. And while Al and I are both attorneys, nothing said in this discussion shall be considered legal advice. We are simply providing information and education. We recommend that you consult with an attorney in your state regarding any specific legal issue that you may have. All right, with that out of the way, I want to introduce Al Nicoletti. Al, tell us a little bit about your law firm.
Sean, thank you so much for the introduction. I probably should give my disclaimer as well, right? I'll introduce myself, give the disclaimer, and tell a little bit about myself. My name's Al Nicoletti. I'm an attorney here in Florida. I can go anywhere from Key West to Pensacola, Jacksonville, Orlando. I love the Florida probate niche. That is what we are really going to dive deep on today. You can find me on my Facebook page, my business page. I'm on YouTube. I have my YouTube channel under Al Nicoletti. You can find the Al Nicoletti Show on iTunes and Spotify. You can also find me on Instagram with all the micro content that comes from the podcast at Attorney Nicoletti. And of course, Sean, the disclaimer, this presentation, this discussion does not provide legal advice, nor does it provide any attorney-client relationship. The matters discussed herein are educational and informational only. Let's dive in, Sean. So I love the Florida probate niche. You ask away.
Yeah, so why do you love Florida probates?
I've learned to really like it because I can make it an efficient system, right? So many types of practices in law can be long and drawn out. Some things just keep going on and on. What I love about probate is it's finding a solution to somebody's problem where they can't sell either real estate, they can't get the money out of the bank account, and it's helping those people find a way to get it done fast, get it done efficiently, and finding a solution by even, for example, waiting until the end to get paid, because a lot of lawyers want payment up front for those kinds of things. So I love it because I found a system that I can make work and make it efficient. And it's just it's a fascinating niche, right? Inheritance is fascinating. It's where's the money going? Who's getting the money? Is there a will? Are there other wills? Are there beneficiaries that are clashing? They don't teach you this stuff in law school, right? They don't teach you what the real world is with inheritance. So understanding the family trees, understanding how it breaks down, also understanding how it is on title is so fascinating.
Now, you're licensed throughout all of Florida, right? So you travel. You basically will do probates in any county in Florida. Is that accurate?
Correct. Any county. It could be Jacksonville. It could be Highlands County in the middle of Florida. It could be Pensacola. It could be Miami-Dade, Naples. It doesn't matter. Anywhere in Florida. And every county's got their own system.
Now, with COVID, we've noticed a real shift in the way the courts operate. Are you having to travel throughout Florida for in-person appearances, or is it pretty much now all online and by video?
Online and video, and also a lot of email communications as well. So pre-pandemic, what was the drill, Sean? So we get all the petitions signed, we get what we need from the client. The next day, it's ex parte, meaning we just go down and see the judge. There's no opposition. We go see the judge. We show the judge everything. Boom, 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 done, signed, right? And then COVID hits, and that's when it was just like, what are we doing? We're going to do Zoom for every single probate, and the system became more of like an email transmission or they have like the e-filing system where things are filed through the Florida portal. So ever since COVID, the court system shifted away from all of the ex parte. We can't go to court. We can't go down there ex parte. So what we do is it's a lot of emails. It's a lot of filing. It's a lot of, I'm a millennial, right? Like if you know how to use computers and you know how to use the online system, you can really figure it out. So we really had to move to a digitized and electronic system.
Now, you've used the term ex parte. I know what you're talking about because I'm an attorney. I doubt a lot of our listeners fully appreciate or understand that. Can you explain a little bit more about what you mean when you use the word ex parte and what that looks like in the process of a probate?
All that really is it's just us as the lawyer represented by one party going to see the judge without having any counsel. There's nobody that's made representation from another beneficiary. There's no opposition. It's just the lawyer being able to go to the court with nobody contesting, nobody having questions on any of the documents, and going down, explaining all the orders, explaining the petitions, and getting the court orders. So it's really just what's beautiful about probate is unless a beneficiary is contesting, a lot of these things go quickly because there's nobody contesting anything.
So you've mentioned if a beneficiary is contesting, then you can't do it ex parte. Are there any other circumstances that would prohibit you from going to court, without giving notice to the, any other parties and doing it ex parte?
So a lot of the probates that are like simple, or not a lot, many of the probates, we get all the consents from the beneficiaries, right? That's the whole goal. Everybody's in agreement to get this thing done. But there are times maybe when somebody's in prison or the person's out of the country, it's really hard to, they don't have an email, they don't have a mailing address, or they don't have something that we could do what they call formal notice, right? Really, we're getting really in depth with some of this stuff that we don't always have to go through, but we would just do what they call formal notice. It's almost like service of process in a lawsuit, right? We're filing a document to put the beneficiary, whoever they are, wherever they may be, on notice that there's a legal proceeding, and that if they don't respond within a certain period of time, then the court will recognize that, default them out, and enter the court order.
One of the things in Arizona that we come across that requires us to, do a more advanced level of probate is if our client, the personal representative or soon to be personal representative, comes across a copy of a will but can't find the original. How is that handled in Florida?
You can get pretty creative with this. So the basic picture is this: you need the original will in Florida. So whenever these investors or sellers call and they're just like, there's a will, but there's only a copy. Where's the original? You got to find the original. And sometimes when these deceased, they do their estate plan, sometimes the lawyers will immediately deposit the will in the courthouse and let it sit, right? So if you're asking where's the will, it may be already in the courthouse. But as we know, many of them don't do that, right? So they hold the original, and then most of them have it. But in circumstances where they don't have it, and there's only a copy, that's where we can get creative. That's where I get really creative on my side, right, Sean? So like we find a way. It's like, are all the beneficiaries named in the will the same as if there was no will? So then we don't really even need to go through any admitting a copy of a will process. We can figure it out on a different level. But if there's times where it needs to be admitted, you have to do a copy of a will proceeding, but it's really hard because the burden in Florida is that if it's an original will and it's authentic, it's presumed it's a will, it gets into court. But if it's a copy, it's presumed that it was revoked and or destroyed, and you have to now do a legal proceeding to now prove that it was not. So it's really interesting because if it's a copy, I like the scenarios where I look at that copy and say, hey guys, are the beneficiaries named here the same? Are you all the same named in here? Why are we dealing with this? Let's make it really simple, super simple, and figure out a creative way around that. Get the court order, boom, done. Why go through the whole thing?
Now, you're real active in the real estate investor community. Why do you think it's important for real estate investors to have some working knowledge of the probate process?
I think it's important because, number one, it helps you when you're at the initial consult. When you're with that first seller, it makes you stand out and different, that you have some basic knowledge of probate, that you're not just like, I don't know what this is, I can't help you, right? They want help, and they want somebody that's going to bring some kind of solution. So I get investors that'll call, say, bottom line, what do we have to do? I'll get the investors that'll be like in the weeds, like, what does this mean? What does that mean? The beauty of probate, Sean, is you don't have to know all the words. You don't have to know the definitions. You don't have, like you and I, we know what the final accounting is, if there is one. We know what inventory is, but that's not important for investors. What they need to know is who's around, what's around, when was date of death, what's the story? Find out the story, because it really helps us, right, in what we do. Then we know where to go, what forms we need, how big the probate's going to be. Is it going to be a small one? Is it going to be a big one? Is it going to be, wait a second, mom was out of state when she died. She resided out of state. We're not doing what we normally do. It's a different kind of probate. So finding out these little things help us. And then it makes them look really smart in what they do, because they're always finding a solution to the problem.
One good target market for real estate investors is, probate properties, if you will, right? And figuring out, whether or not there's somebody who's, passed away, and you now have a property that needs to be disposed of, and it maybe the beneficiaries, they don't a lot of times want to put in their own money to make improvements and things like that. And so it's a pretty good mutually beneficial relationship between, say, a real estate investor and a personal representative or seller in that case. In Florida, is there any way to access, like, probate lists or other information that investors could use to potentially find leads on probate properties?
So there's a couple things. There's companies out there like Probates Daily, Foreclosures Daily. They have the leads, right? They have like the pre-foreclosures, they have the pre-probates, and if it's probate, that means it's already in probate. So there's companies with different leads. But there's things like tax delinquencies, Sean. So in Florida, that's a whole other thing, right? About tax delinquents and tax deeds. So every year, homeowners got to pay their taxes in November. You get a better discount in November. If you don't pay it by April, you start going on a list. By June, you're really on the list, and people are starting to bid against the interest on the taxes owed, right? So that becomes what they call in Florida a tax certificate. Well, that owner or heirs have 2 years from that certificate within which to redeem and pay back those taxes. Otherwise, that tax lien holder can start pushing it to a tax deed sale, right? So those leads are really interesting because the mortgage may be paid, so there may be a lot of equity, but the reason it's even a tax certificate or going to a tax deed sale is because the person can't pay, they forgot to pay, or they're dead. So those are probate leads that are in there because the family members don't even know about it. That's why the person died, the taxes aren't being paid, and then 2 years later it's going to a tax deed sale. What's great about tax delinquents is they're calls to action. They are things that are going to make those seller heirs move and get off the chair to do something and either make a deal or lose the property to a tax deed sale.
So let's talk a little bit about the, ins and outs of probate. So let's say hypothetically an investor enters into a contract to purchase property, opens escrow, and all of a sudden they discover there's an owner still on title who is deceased. Where do they go from there?
First thing, pull title. You want to pull title up front because you want to know back taxes, phantom mortgages, multiple judgments on the property, and even a bonus if you know the names of the heirs and some information. That title company can run checks and lien searches on the heirs, because as we know, Sean, the deceased is on title, but the heirs aren't. And what happens when the deceased transfers to the heirs, and now they are all on title, and one of those heirs has an IRS lien or a judgment, right? That could really ruin the deal. So pull title, run lien heir searches if you can. If you're able to do that up front, it's really creative. And then after that, asking the story, right? You want to find out, is there a will, right? Is there no will? Is there a spouse? Who's the spouse? That's really important in Florida, Sean. Spouses have huge rights. And so you have to find out spouses. Then kids. Who are the kids? Kids all time. All time. That's really important too. So many stories about that. And then you go no kids, grandkids, great-grandkids. And then you go up. It's parents, grandparents. You want to find out the tree. I have a whole tree that I have a whole thing about that now. So finding out those things is really important. Then once you have that basic understanding, that's when that seller would reach out to the lawyer to say, hey, we're interested in doing this probate. What do you need from us, right? And it depends on the county. Is it as simple as Duval, where a couple petitions get some things going and done? Or is it Miami-Dade County, where you need affidavits and this thing and that thing and checklists? Or Charlotte County, you need checklists? That's the importance of working with somebody that focuses on this, because I know each county now. Like, I know what they want. So finding out what county it is, where you're going is huge. And I think the ins and outs is understanding that what probate is a transfer of title over. And now those heirs, once they're on title, have authority to sell it.
In Arizona, spouses can own property as community property with right of survivorship. And then you can also have joint owners who own property as joint tenants with right of survivorship. And of course, the right of survivorship language means that when someone dies, the ownership immediately transfers to the surviving owner. And so husband and wife own property, community property with right of survivorship. Husband passes away. A lot of times, we'll be consulted on that issue because, somebody's passed away and, then it's like, well, what do we do? And it may be as simple in Arizona as just recording the death certificate. And once you record the death certificate, boom, title's already placed, automatically placed in the surviving owner. Is that similar in Florida? Because I think you guys have tenancy by the entirety or along those lines. So how would that work in Florida with that type of ownership?
It's a very interesting question. So if you have a deed where it's husband and wife, right? That's the tenancy by the entirety. It's all about title, Sean. It's all about the deed, who's on the deed. So if husband and wife are on the deed and husband dies, all title needs is the death certificate and it moves over to wife. Boom. Now you're in touch with wife. She can sign the documents, you sell it. But then all of a sudden wife dies, guess what you need? Probate, right? Unless there's change in a ladybird deed, there's retitling, we can get into all that. But here's what's unique about Florida. And Florida has a homestead law. And when it comes to probate, it's really crazy. If husband and spouse are married and husband's the only one on the deed, and they've been married 50 years, and they have kids, they have 3 kids together. Husband dies, he's the only one on the deed. The spouse and the kids both have an interest in this property. And they have 6 months within date of death to elect 2 options. Either the spouse can take a life estate so she can live there for her life with remainder to the 3 beneficiaries when she passes. And if she wants to sell, they all need to be on the contract together, right? And all sign the closing documents. Or she can elect to take 50% with 50% divided among the three. And what's so crazy about this is like people are like, I've never heard about this before. Life estates are weird, Sean. So life estates are calculable interests. The younger the spouse is, the bigger the percentage. The older they are, the larger percentage. So that's where you get creative with, if you're in that 6-month window, is the spouse 30 and they get a huge amount, or now you've passed the 6 months and they're locked in no matter what on a life estate, and it's kind of a trap, right? Because then they can't sell without the beneficiaries. So that's what happens with those things, right? If you don't put people on title together like that, it's crazy. Now, if we're talking about land or secondary property, if we're looking at husband's the only one on the deed, and they've been married 50 years and she's not even on the deed, right? What happens? If those 3 kids are the same as the spouse and the husband, it's 100% to spouse. If there's only a spouse and no kids, 100% to spouse. Now, if one of those kids is not of the husband but of the spouse, 50% to spouse, 50% divided among the 3. And if one of those kids is of the spouse and not the husband, 50%, 50%. It's crazy, right? Like thinking about this whole strategy is like, it's amazing. That's why you got to ask these questions. Is this where they lived and resided? Or was this a rental property? Or if there's no house, right? There's no homestead.
Now, in the scenario that you described where it's vacant land, husband's only on the deed, husband passes away, children, same relationship, nothing, from any other relationships amongst the spouses. In that case, do you still have to do probate to effectuate the transfer to the wife?
Yes. If husband's the only one on the deed and she's not there, yes. Because when you pull title, underwriting is going to say, well, he's the only one on title. We need what they call a determination of heirs based on the petitions and the probate to determine who's here, who needs to sign, who may need to sign the deeds at the title company closing, who may need to sign consents in the probate. That's what's crazy, is that title insurance plays a massive role in probate. Is title insurance companies do not want to take on the risk and the money by missing these kinds of things. So they want this in Florida, they want this done to make sure that nobody is going to come back later. So in those scenarios, yeah, it's crazy. Married 50 years and not on title, still need probate.
So in Arizona, and we're talking about probate, and we're kind of using that word loosely. In Arizona, we have basically different categories of probate. One category or option is to do an affidavit of succession to real property, or affidavit of heirship, as it may be referred to in other states. Now, that's technically not a probate, but the affidavit has to be approved by the probate registrar to make sure everything's in order. And then once it's approved, we can go and record it. And then that affidavit is what causes title to transfer, and nothing more is done. No, estate administration or anything like that. The real property is just transferred. And there's certain requirements that I won't get into because it's, an Arizona thing. Then there's an informal probate process where, the affidavit of heirship won't work for one reason or the other. But we have the opportunity to go and file with the court, and the probate registrar reviews everything and signs off on it. We don't have any hearings or anything like that. It's kind of almost sounds like your ex parte or summary, proceeding there in Florida. But we don't have hearings, and you go through and you do your accountings and inventory and closing statements, things like that, and you close it out. And then finally, you have the formal probate, and that kicks in where you go and you file, and you actually have to request a hearing. It can't be ex parte; it's a hearing in front of the court. And when you're there, the court reviews everything and makes a determination, but then sets future hearings. And so it's, kind of an ongoing thing where you're having to go to court, now it's either by video or phone mostly. But nevertheless, you're still having to have these formal hearings, and that's a formal probate. It's a lot more expensive to do a formal probate and a lot more time consuming. Is Florida structured in that way, or is it all just kind of, hey, one probate and this is how it's going to happen?
Yeah, so they don't have affidavits of heirships to avoid a whole probate proceeding in Florida. Like, probate proceedings are court proceedings, and we have to go through the court process to get it done. I know Texas is kind of like that too. It's like, if you find everybody, they all sign off and they do an affidavit of heirship. There is none of that in Florida. It is literally the heirs, we got to do probate documents. We have to file it with the court. We got to get the court to review everything, and then and the court approves it from there. That's what they have here. But yeah, you're right. So there's three flavors of probate, right? There's summary, which is the one that can go really fast because the assets are below a certain amount and you have everybody in agreement. There's no issues with creditors. Boom, done. Then you have ancillary, which is where the person lived out of state. They resided in Ohio. They resided in Arizona. Hey, maybe Sean's working on the Arizona probate, right? So they're out of state and they owned land in Highlands County. They owned land here in Florida, but the heirs didn't know about it. So they call that ancillary, almost secondary probate. And there could be a summary or a formal depending on the amount of the asset, right? But the big one that Sean's talking about is the formal administration, where assets, there's like a threshold in Florida, it's $75,000. Homestead is excluded. Homestead counts as zero. So there has to be homestead plus a bank account, $80,000, a house, $100,000, $1 million, right? Then it shifts the probate to what they call formal administration, where we now have to get that executor person that everybody talks about loosely, the executor, but in Florida, it's called personal representative. They have to be qualified. You have to make sure they meet the requirements, and everybody, you don't need a unanimous to get that person appointed as personal representative. In Florida, you just need a majority, but usually everybody's on board anyway. They get appointed, and now they are in charge of being able to gather all the assets, take the letters of administration that the court enters once they're approved, to go to the bank accounts, for the secondary and third property, sign the contract for real estate, sign the contracts and documents at the closing title. But fun fact for you, Sean, in Florida, for that primary residence, that personal representative cannot sign on behalf of everybody. It's really interesting. All heirs. So the theory of homestead is that upon death, whoosh, title moves immediately to everybody. So they have what they call the vested title. I know, it's crazy. So you're thinking, the personal representative can sign for everybody. No. On secondary property, rental property, and land, that's a different story. So when you get into formals, we don't always need it, right? We don't always need that. But if we do, they're longer. We have to run that newspaper publication to creditors. Everybody comes out of the woodwork. We have to find everybody. And then they usually can last about 4, 6, 7 months. But what's beautiful is that no matter what, and we could talk about this, the sale of the property, that can be done right away. A lot of people don't know that. They've usually heard that in order to get the property sold, you have to wait the 6 months. And probate doesn't even take that long. Don't even get me started on that rant. Probate in Florida can take a matter of days, weeks, a couple of weeks, maybe a month. Doesn't have to take that long. And what's so beautiful about it is that at least the property can get sold and everybody can move on with the deal. It's just that in that kind of case where the money has to be held, it's got to be held a little bit longer. So that's what's really cool about it.
So I want to follow up on that. So talk to me about the timing here. So investor has the property under contract, realizes, hey, we have a probate issue. Title company says, call Al. He's the best in Florida. They call you and retain you. And now you're going to go through and prepare the paperwork, file it with the court, et cetera. And at least, with our office, when we're consulted on probates, the question is, when can we close escrow? So, tell me from the time that you get that call, and of course there's going to be, I'm asking for a generalization here, but from the time you get that call, if everything goes smooth, all the heirs agree, there's no issues, and the soon to be personal representative does everything they're supposed to do in a timely manner, what are you looking at on the short end of, hey, best case scenario, we can get you closed by, a week, 2 weeks, 3 weeks, what's the timing look like on all of that?
So, of course, it depends on the county, right? So if we're talking about Duval County, it could be 2 to 4 weeks. So that's Jacksonville. It could be a matter of 2 to 4 weeks, 1 to 3 weeks. You're looking at, in that month frame, everybody's in agreement, no questions, no issues, 2 to 4 weeks, 1 to 3 weeks in that area. Now, if you're talking about some of the smaller counties like Marion, they want mail-in orders, so there's a little bit longer of a process. Some of those judges have to go between counties and counties, so they're never like there in front of their desk all the time. So sometimes you could be waiting a month and a half in some of those counties. Or Miami, surprisingly, I used to think Miami was going to take a lot longer. If you have all your ducks in a row and we have everything we need and we submit everything, sometimes in Miami it could be 1 to 3 weeks, 2 to 4 weeks. I mean, that's what's really interesting. And when I say timing, I mean, Sean, from date of filing the probate to then getting the court orders, right? Not from the date of initiation of contact of the whole story, because you got to get everything first. There's no way that the timing can be based on from the time they reach out to the time it gets done, because they could take forever. Some of these heirs can drag their feet, right? So it really depends. I mean, you have Lee County and Collier County. You're looking at about a matter of weeks. It could be a month. Some of the smaller ones, again, it varies. But nonetheless, Sean, the big picture here is everybody has heard, whoa, 6 months, 9 months, 1 year. It's like, I know you and I both agree. It's like, I don't know what planet that's on, right? Like, I don't know where that comes from. And I think that comes from the fact that lawyers try to do everything in their business. They try to they wear multiple hats with all types of law. And so they don't focus on the efficiency side. How do you get this done? What are you doing? What needs to be done? And so I think there's a disconnect between people that specialize in it and people that do it.
Talk to me about what happens if you have an heir who decides they don't want to sell. We've seen situations in probates where, mom and dad passes away, but one of the children had been living with them and they have no interest in selling the house and moving out, but they also have no interest in paying rent. And so, they're not going to want to cooperate and they're not willing to cooperate in the process. What do you do with an uncooperative heir?
Interesting question. So it depends on the type of property. If we're looking at homestead property, you really have two options. One, the investor really tries to talk to them about, look, well, maybe you're upping the offer a little bit. You throw them a little bit of extra money at the closing. I don't know. You work out a different contract deal, give them more motivation, right? That would be finding a solution to figuring out what would make them happier, because you're never going to make them all happy. But finding out happier is the first step, right? But if they don't, homestead property, what did we talk about? Homestead title immediately goes to all beneficiaries, right? So you need them all to agree. And if they don't all agree, you're looking at what would be, number one, a probate. So title moves to all of them. And part two is what they would call a partition, a forced sale of real estate. So when the title moves to everybody, it now creates equal interest in the property. And in Florida, under the statute, says, yeah, the partition is allowed, meaning all of them against that one that disagrees can go to an attorney, retain the lawyer, and force the sale to a public or private listing. They can go to public auction or private listing, and it could force the hand, right? They may go, whoa, 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 I want to agree, right? Or they still don't agree, and the property can move to a public auction. Or maybe, it usually doesn't happen this way in Florida, but a ready, willing, and able buyer can submit a contract, it can be reviewed by the court and approved, and the sale is going to that buyer, right? So when you have those scenarios where they're uncooperative, you have a partition. It's really unique. It's a two-step process. Obviously, the second part is not like probate, 2 to 4 weeks, right? It's like it could be 2 to 3 months. You have to do service. It's different. Part 2, non-homestead, meaning it was the rental property, the secondary, the land. In those cases, if you have a majority of people in agreement and there's a personal representative, you may not need to do the partition. All you may need to do is get everything lined up, get your CMA, get your repair list, get the record clear, and do formal notice on that heir, and have that heir come before the court, set it for hearing, come before the court and state why that should not be approved. Because if all of the beneficiaries are in agreement but that one, what's the reasoning? And usually it's favored that it would go more to, it's got to be sold. Maybe it's up for public auction. Maybe it's in foreclosure. So there's an urgency to it. There could be good argument, right? So you don't need a partition necessarily in the second part, but those are options available.
I want to back up and talk about the partition because I think it raises some interesting things for investors. So on the homestead, where you say that basically title automatically, vests in the heirs. So do those heirs then have an immediate right to convey their interest? So let me give you a hypothetical. And I've seen, it play out here in Arizona, kind of along these lines, but, you have 4 siblings, 3 of which want to sell, and maybe even they want to sell to a specific investor, but you have a holdout, right? That heir is saying, nope, not going to sell, never going to happen. I'm not going to sell for any price. So is it possible for the 3 heirs to convey their interest to the investor and then for the investor to do the partition action?
In short, yes. That's what can happen. Right? So there's really 2 options. Either the heirs are the ones that do the partition. And in Florida, they got a new law about the about heirs versus heirs. So now if it's over a certain percentage of ownership on the property, that heirs that's in disagreement has a right to buy out everybody or have their rights heard first. And if they don't respond, then you move forward with the normal partition. But yeah, that's what's really interesting is if they don't want to deal with the lawsuit and the investor comes along and says, hey, I'll buy out your interest for this number, and they want to do a quick claim deed, not quick claim deed, right, let's make sure everybody knows that. It's not the same. And they do it to the investor, and then the investor is the one that's holding the 3/4 interest. Let's just say there were 4, the 3/4 interest, and does the lawsuit against the 1/4. Then great. I mean, that's possible. Yeah, it's possible to do.
Yeah, because a lot of times, the heirs, they don't want to spend their own resources on an attorney, and they don't want to have to put the time, effort, and energy, and they just want to be out, right? I mean, they're like, this was mom and dad's home, or, I don't really want to be messing with this anymore. I just want, whatever I can receive from the transaction. Or from the sale, and I want to be out. You investor, you go deal with it. And frankly, it's not a bad idea for the investor to deal with it. I mean, they have the opportunity to, probably, build that into whatever amount that they pay to those, those heirs for their interest. Now, on a partition action, is there any fee shifting? Meaning, in Arizona, we don't have that where, if I go and try to partition an action for a client or try to partition a property for a client and my client prevails, because generally there's no defense in a partition action, my client prevails, my client's out the attorney's fees that they paid to our office. Is that the same way in Florida, or is there fee shifting?
So I don't know fee shifting, but there's attorney's fees provisions per the statute, right? So there can be a recovery through the final judgment and paid out of the sale for attorney's fees and costs expended and borne equally by everybody.
Oh, okay. So if one side has an attorney and the other side doesn't, then that attorney, let's say they have a quarter interest, they're ultimately going to pay a quarter of the partitioning party's attorney's fees. Is that accurate?
So I guess the way I look at it is, if whatever my attorney's fees and costs expended, it comes off the top, right? We get paid first, and then it's split among everybody.
Right. Well, and that raises a interesting topic as far as payment of attorney's fees in probate. Are attorneys in Florida allowed to recover their attorney's fees out of escrow or out of the sale of the property?
Sure. I mean, as long as the client's in agreement with it, and they can wait and be done at the closing, there's nothing preventing that.
Now, is that something that your firm offers to do?
We can wait until the closing to get paid. We can wait until the closing to get paid. We want cost up front because we have to have the cost, but we can wait until closing for the attorney's fees.
Yeah, and when you're talking costs, you're talking the third-party costs, such as filing fees, service fees, notice to or publication fees for notices to creditors and things like that. Not a significant sum as far as costs go. Generally under $1,000.
You're looking at, sometimes it could be like $250, right? If it's just a homestead property, there's no creditors, we don't have to do really anything. It could be $250, could be $350. Usually max maybe $700. So you got the formal administration plus the newspaper publication. So you're not looking at a pretty penny when it comes to costs. I mean, that's what's great about probate, is the overhead is not a lot either. So you're not taking a huge risk on costs when it comes to doing all of this. And what's beautiful too, Sean, let me explain this, is the investor can pay for the attorney's fees and costs as well, as long as the client consents that the third party is paying and they fully understand the legal and ethical obligations. They are more than welcome to pay the attorney's fees and costs throughout closing or beforehand. That's what's really cool.
So the way you're laying everything out here is great. I mean, it makes sense to hire an attorney to do the probate, especially the way that your compensation structure may be set up. Because one of the things that happens quite regularly is somebody dies, and they may even have a little bit of money in the bank, but the main asset tends to be the real estate. So, the personal representatives are now being asked to come in and start, funding the costs of, say, the probate and different things out of their pocket in the hope of at some point being reimbursed. The personal representative may or may not have the ability to fund those costs, nor may they even want to. So what you're saying is, hey, look, we can avoid that scenario. I can either take payment from close of escrow, I can be compensated from the investor with the proper disclosures, all of that, so that the personal representative who is having to deal with this isn't having to come out of their personal pocket to fund this process. So I mean, and tell me about that. Tell me about the significance or the benefit of having an attorney involved in the probate process.
Oh, it's huge. I mean, first of all, we understand where to go with the laws, right? We understand who's next in line with the inheritance. That's very important for title insurance. You want to make sure you got the right people, the right lineage line. You don't want to miss anybody, and getting it done the right way, because if you have it done incorrectly, it could mess everything up. So the importance is, like, Sean, I could go through stories of lineage lines. Like, there was one case, like, this is why you need lawyers. So there was one file where mom dies, and mom had no will, no spouse. There were 7 kids, and of the 7, 2 died before mom. And there's legal significance behind that with the inheritance line, Because if the two that predeceased mom, you just drop down to their lineal descendants. You bypass whatever spouse they have, you drop down to their lineal descendants. And so of those two kids, one had 3, the other had 2. Homestead property. So what did we learn? They all get it, right? So of the other 5, one of them was in prison and then the other was incompetent. And so what do we know about those scenarios, right? Who has the power of attorney? So if you don't know these things and how to think these, you don't see it like you and I, Sean, like on a daily basis. Like we see so many cases over and over. We got stories for days. And if you don't know what the title underwriter needs, you could be in a bad situation, right? Underwriting in Florida, they want the original POA. They want to record it. They want to make sure it's authentic. Does it allow for a probate transaction? Does it allow for a real estate transaction? Because if it doesn't, you got problems. So in that case, both POAs were good, approved by underwriting, allowed for a probate, allowed for a real estate transaction, and all heirs, all of them, ended up signing everything. And it lays out the true inheritance, and you have to be careful too, because can you imagine what the fractions were in that distribution? I think at one point of the ones that were on the bottom, it was like 1/28 of a whole. And you got to be super careful, because if it wasn't just mom on title, but it was like another random person, it'd be like 1/28 of a 50%. You got to make sure those distributions are correct. So the importance of it is somebody that understands these distributions, the inheritance line, when to be careful with all this stuff. It's important.
Now you've mentioned title companies. Is Florida a attorney closing state or a title company state?
Both. Yes, you don't have to be a lawyer to have a title company. It's really interesting. I don't do closings, so what's really nice is I focus on this niche big time. I get down in it. But yeah, you could be a title agent and not be a lawyer. I think there's special rules though, right? Like if you're a title agent, not a lawyer, I don't think you can sign the quitclaim deeds. I don't think you can do certain types of transactions. There's some benefits to the attorneys being title companies, but Florida is just, you can go all day.
And talk to us a little bit about the significance of the probate attorney having a good relationship with either the closing attorney or the title company in working through the probate process to make sure that, title is, properly being cleared.
So important. There's so many things through title you got to be careful of, right? Legal description. Making sure that the property that's being sold has the right legal description, so when the underwriter writes the policy, it's the property you're buying, right? Like that, number one. Number two, making sure that there's not going to be something that pops up later that nobody knows about. A mortgage that nobody knew about and it kills the equity. An IRS lien. So working and understanding what they're looking at on title helps us, because, it could kill the whole deal, right? And also, what is the underwriter looking for, right? I'm not talking about the title company. Title company is the agent. They're working for the behemoth, the one that's in the corporate office, that's in the box, that's looking at the deeds and saying, hey, are we going to write a policy? What do they want, right, Sean? So many times I've seen, I had a case last year where there was a personal representative deed. One person died, but we needed a deed to the other person, and then they had kids, and I thought, we're good, we're done. And the importance of it is we didn't know that there needed to be another motion to approve that transfer of a personal representative's deed. And we were like, I wish we knew that. So that's why you ask questions. Important to know these little things up front before you do them, because you need to know, what do they want? Do they want the certified petitions later? Do they want the recorded orders and stuff later? What do they want? Because every underwriter is different. Everyone, every single one. I could go through stories about it.
You mentioned liens. One of the things that we're always having to deal with here in Arizona are liens related to, the final illness or the long-term care provided by the state of Arizona. And they'll record those liens, and then all of a sudden now, we're trying to get a property sold, and we're having to negotiate with the state and figure out how much they're going to accept, et cetera, from the estate to release that lien. Do you have the same issues in Florida?
So if we're talking about things on title, that's a whole other thing that title handles. If we're talking about things like creditors, right? We're talking about they're really trying to get you, Sean.
This is this is the first live stream. I will not make that mistake next time. I forgot all about my home office phone.
So they teach us all about being lawyers, but what nobody knows is how to do the video stuff. So you'll get it each time. So where were we? Where were we going? Liens. So liens on title is a whole other thing. Those have to get resolved with the title company, and those are known creditors. But if they get paid off, then they're off, right? They're done. But are you talking about creditors like of the deceased?
So no, yes. So for example, one of the ones that kind of is tricky in Arizona is what we call access liens, or liens from the state, using federal dollars, like Medicare, Medicaid, to provide for the last illness, for long-term care. And, somebody's gone into a state-funded assisted living facility for the last 6 months of their life. And, so the state then sees that they own a home and, may have some equity in that home or own other real property. So they record a lien with the county. And then we have to negotiate those. Do you have that same issue in Florida?
I don't think they should be doing that if it's homestead property also. Homestead plays a huge role. So unless it's a security instrument, like a judgment or a court order, or a mortgage or federal lien, and certain like roofing liens and pool liens, those other things shouldn't attach. If it was the person's deceased homestead, and very few things get attached to that. So that could be challenged especially through title insurance. If you get the court order determining homestead, it can knock a lot of those little things off. So very different in the world of Florida. I don't know if they have homestead in Arizona. Very protected here.
Yeah, they do. In fact, that law is changing as we speak. Starting next year, there's going to be some major changes to it, but that's neither here nor there. But that's good to know that, when you're dealing with homestead property in Florida, you have the ability to clear a significant amount of liens. Obviously, consensual liens, though, can't be cleared, right?
Consensual liens,
meaning like somebody enters the deceased had entered into a mortgage.
Security interest, right?
Yeah.
Very different. If it's a security interest, those things don't get wiped off. If they are security interest on title, they could stick, and they have to be reviewed by title underwriting, but those could be potential problems. We rarely see little things like that. You'd be so surprised. Like, I'm sure that pops up like once in a while. But really, a lot of the things that pop up are a mortgage. Maybe there's a judgment. Rarely see the IRS lien. Back nuisance liens, those aren't coming off, right? In Florida, they got nuisance liens, demolition liens, all those weird things. Those have to be negotiated with the county. They're not coming off. They don't even come off with the tax deed quiet title, right? They have to be negotiated with the county, and you get the whole rebate program if you do that. But that's all. That's what's interesting about my world, Sean. That's the title world. My world is focusing on what did the deceased have, who is their lineage, where, if there are creditors or no creditors, and finding a solution by waiting until the end for payment, knocking this thing out, getting it done efficiently and timely. It's beautiful.
Talk to us a little bit about what happens when you can't locate a beneficiary. You talked about, having somebody potentially in prison, things like that. But let's just say flat out, you've done all of your due diligence, you've run your skip traces, you've hired your, air search company, and they just flat out can't find this person. how do you get the probate completed in that circumstance?
So two things. Have you considered the genealogist yet?
Yeah, your heir search person. But yeah, so a genealogist would presumably fall in that category. But yeah, you're right. I mean, somebody who's gone and done these, searches to figure out, where this person is or who this person is even.
Very rarely is there nobody. And so where my next thing would be to say is the genealogist. Because the genealogist that specializes in probate, they take the death certificate and they perform a whole story. They do a whole story, and if you find the right one, they can testify to the whole lineage of that person, and even if they were married, going down the maternal line of that person as well. So it's very interesting with genealogy searches, because there usually could be somebody far down the line, nieces, nephews, aunts, uncles, and keep going. Now, two things. If there's absolutely nobody, and after we've seen that affidavit, right? Like, I would want that affidavit in court. You and I both know I want to see that affidavit that says there's nobody, because I don't want to hear it later that there was somebody and they come back, right? That's when we get into a weird experiment where eventually the heir in Florida is the state of Florida. So we've never had that. I'm sure it's coming. I mean, I'm young spring chicken, so I'm going to see that eventually, right? I'll probably see that soon. And the state of Florida is the heir. Maybe there can be a motion to approve sale because they're not a blood. There's no homestead, right? State of Florida is not blood to the person, so it's not truly a homestead property. And maybe there can be a personal representative, independent, not us, independent, appointed, maybe, and then there's a potential buyer. So there's a motion to approve sale, potential contract, lay the record, and any money is put in the state of Florida. And it's held there for a while until I think it's after like 10 years, and then it goes to like some kind of fund. But, Sean, of course, I have a story for you. There's the other one where they're somewhere, but you just can't find them. You did your skip tracing, you had your PR look, you did the genealogy. There's some, but they just don't know where they are. They're not responding. So I had a story where the property, non-homestead, so we don't have to worry about partitions and buying out interest, non-homestead, we couldn't find them. There was one, and it was a small interest because the person dies, they were survived by a spouse, but they had kids that were different. And what did we talk about before? If they're different, it was 50-50. And of that 50% with the kids, one of them only was the one that was different. So it was a smaller percentage. We had everybody on board. We had kids of the wife and a majority of the kids with the husband. But we just couldn't find one. I called it the Cuban probate dilemma, because there was one heir. There was only one that we couldn't find. And so at the time I was thinking, we're out, where there's no way. But we found a way where we were able to lay the record, do a motion, get a contract, and we set it for hearing. We explained it to the judge that there's a looming sale, there's a looming tax deed, there's a looming auction, that they may not even get the amount for the contract price. Here's everything, and approve the sale. And so we literally, this is what was crazy, Sean. We filed it on a Friday. We got a case number on Monday. For some reason, the stars aligned and everybody answered the telephones. We got the JA on the phone. We got a hearing on Tuesday, the next day, and got before the judge on Zoom and signed the order. The tax deed sale was on Wednesday, and the investor, because of the order authorizing sale, paid off the taxes and salvaged the deal. So in cases like that, you got to see what kind of situation it is with the missing heir. But of course, that person, that client, you got to take the steps to do due diligence to go find them. So, I mean, so they took steps to really go look and search and ask and find out. And there's just there was really no legitimate responses, nothing. So, and then what's your next question? Well, what do you do with the money? And in Florida, when that property sells, what we're going to do is we're going to file a motion to deposit the money in escrow in the court registry. And so what's going to sit is that person's name, the money, and they can, on their own time, come and try to do one of those surplus funds recovery and get the money.
Great story. Well, we have just a minute or so left. Is there anything else you would like to add before we wrap up the show today?
Probate is amazing. I can wait until closing. We get these things done quick. We make it happen. I think this is a fascinating niche. And I think the last thing I'd say is, Sean, thank you so much for having me on this live thing. I hope to do this again with you. I think it's really interesting. The whole probate stuff is interesting. Don't shy away from probate leads. And people like, they hear probate, I don't want to do. It's like, no. They can be awesome. And you work with the right people, the right lawyers are involved. Things can happen. It can be a beautiful niche.
Thank you, Al. We appreciate you coming on, and it was fun. We also are live streaming this on YouTube. So if you've not gone to Real Estate Investor Legal on YouTube, please do so. Like us, follow us on there. And thank you all for your attendance today and watching our show. And that'll end our stream for today. Thank you. Have a good day.